Law Simplified with Justice is anchored by Justice Maduforo. Tice Madox Solicitors is results-oriented, but with a distinctive approach tailored to our clients' needs in our specialist fields: immigration law, criminal law, employment law, commercial law, family law, and contracts law. We are well equipped in our litigation and advocacy for the benefit of our clients, corporates, and individuals. Why not visit us at 5 Oakfield House, Oakfield Road, Ilford, London, IG1 1EF. We are just 15 minutes from Liverpool Street Station. Tice Madox Solicitors. Try us. We are professional.
Hello, ladies and gentlemen, and welcome to Law Simplified with Justice. I am Justice Maduforo, your usual regular host on this platform, Law Simplified with Justice, the program that brings the very best of topics in all areas of law, and the program that kickstarts your consciousness to law and enables you to take action. Over the course of this program, and those of you who are following this program, you will attest to the fact that this program is not just merely for your own information. It also enables you to pass this information over to others so that others can be able to take advantage of the benefits of the information passed on here, in the sense that they will now be able to come to see me on one-on-one and take a well-tailor-made legal advice. On the screen is the address to Tice Madox Solicitors. On that note, ladies and gentlemen, all I say on this program, or my discussant on this program, they are not legal advice. Therefore, you should not and you must not act on anything you hear me speak on this program unless you have come to my office and sought one-on-one legal advice, or in other way, any other means, either by tailor-made advice given to you over the telephone in certain circumstances, and then you can act on what you hear me speak to you or advise you at that stage. Therefore, ladies and gentlemen, this program brings the very best, leading you to Tice Madox Solicitors, where we can serve you in your best interest in matters relating to immigration, criminal, contract, commercial, family. Ladies and gentlemen, in all these matters, you will receive a tailor-made and proper representation, advice, litigation in courts of law, both in court and tribunal. And also you receive the best advocacy in your best interest to ensure that your case is victorious and you are victorious, as the case may be. Ladies and gentlemen, these areas are on the screen, and therefore you must take advantage of this position to take advantage. Call me on the telephone on the screen, more especially the office telephone, and book an appointment to come and see me in the office. Book an appointment to come and see me in the office, and where we can sit down and discuss in detail, ladies and gentlemen. Let me also remind you that if you book an appointment to come and see me in the office for legal advice, not for chats, but for legal advice, those of you desirous of legal advice, even if you have other solicitors, but you feel one way or the other, they are not representing you as you wish to be represented, or the work done previously is below standard, or not apart to what you expected, or one way or the other, you are still not sure of going on with your representatives, or you are not entirely satisfied with the work done, and you want to get a second opinion, a second advice on your case, which is already proceeding or about to proceed, or already you have instructed them but they have not commenced yet. Therefore, you must pay consultation fee to come to my office to seek that quality legal advice. Ladies and gentlemen, as at that point, you may decide for me to take the matter up from there, and we can now discuss it very well. Let me tell you this also, that when you come for me to take matters on your behalf, our fees are very moderate. And guess what? We ensure that you have a payment plan to ensure you that you be able to carry on the fees very, very easily, so that it's not burdensome on you, but at the same time, you will be glad you're getting undiluted quality legal advice. Today, I will be speaking on immigration. Over the course, I've spoken on contracts. I also discussed in criminal matters. And you know that I am police station and magistrate court to the Solicitor of England and Wales. As a matter of fact, you know I'm a solicitor and also a barrister of the Supreme Court of Nigeria and Solicitor of Supreme Court of England and Wales, or Senior Court of England and Wales. I'm also the principal of Tice Madox Solicitors. Ladies and gentlemen, the reason this program comes to you is nothing more not to kickstart your excitement on this program or topics or presentation, but it's a serious business whereby you will understand that law holds whatever we do on the surface of the earth, more especially and in particular in this country, United Kingdom. And therefore, law holds all things together. And in absence of it, anything you have built over the years may collapse. And therefore, there's need for you to seek that proper legal advice to understand where things need to be rectified, where things have gone wrong, and where things you don't want things to go wrong to start with. Therefore, when you come to Tice Madox Solicitors to see me, we take your matters from the beginning, lay the good foundation that's required of that matter in the magistrate court, in police station, crown court, in court of appeal, in Supreme Court, in employment tribunal, in employment appeal tribunal, in the county court, in immigration appeal tribunal, immigration tribunal, upper tribunal, first year tribunal. You want that better representation that you need. And as a result of that, you do not want to make any mistake. And that is why this program comes to you. Because some of you need information. Ladies and gentlemen, information is key. When you are informed, you make the right decision. When you are informed, you understand your case better. When you are informed, properly informed, you will understand and comprehend the advantages and disadvantages, the merits and demerits, the chances or no chances of your case. That is better informed. You will even know your right. You will even know whether you are ripe for an application. You will even know whether you need to exercise a little patience for that application before you can make it. That is why you need this program. And that is why you need Tice Madox Solicitors, so that you will be better informed. I'm talking on immigration today. The topic is deportation. Ladies and gentlemen, deportation from the United Kingdom, if you know specifically. The United Kingdom has ruled out laws whereby foreign criminals or foreign citizens accused of crime, one way or the other, more especially those who have been convicted in this country, can be deported out of this country after they have served their sentence or about to finish serving their sentence. As a result of that, the UK Border Act 2007 enacted and gave the Home Office, the Secretary of State, the power under Section 32 of the UK Border Act 2007, the right, the power to remove foreign criminals out of the United Kingdom. Now, you are all aware of it. I'll save the basics here. The basics are simply what I've introduced, and you're a foreign criminal, you're not a British citizen, and at that, you're not a British citizen at all. Once you're not a British citizen, then you become a foreigner. Even if you have your indefinite leave to remain in the United Kingdom, it is not certain, because that means that it could be revoked. The only thing that assures you is the fact that you're a British citizen. Now, hang on there. To some extent, depending on the offense committed, and depending on the route of which you obtained your citizenship, that could be revoked when such serious offense committed. And these offenses, one do not understand when they occur. Now, let me tell you this, ladies and gentlemen. Remember I told you that I am a specialist in criminal matters, which means from police station to magistrate to the crown court, I deal with your matters. In court, in the police station, making sure that evidence is there or there's no evidence. Either in your favor or against you. Those against you to destroy it. Those in your favor to propound it and to escalate it, ladies and gentlemen, and to present it in a convincing manner. Now, what am I saying that? I'm also an immigration expert, which I'm discussing today. Now, deportation is an intertwined subject, which intertwine between criminal law and immigration law. You see how they all connect to each other. Because once offense is committed, and then what happens now? Immigration kicks in. After the service of that sentence, then immigration kicks in, which means when you are now able to be released unlicensed, having served half of your sentence, therefore immigration power takes over, giving the Secretary of State the power under Section 32, subject to two conditions. One, you have been sentenced to more than 12 months imprisonment. That is, you know that. Some of you in prison get that as a kind of a song, but you understand that very well when you are in prison. And some of you, your words or your children or nephews, cousins, or father or mother are in prison. They have 12 months imprisonment, and you don't know what happens. And you may think they have not been served that sentence. you have been served that deportation notice, and as a result of that, they continue to stay. And they begin to count the calendar when they'll be released after serving half of the sentence. Now, this is why I told you need me. This is why I told you that the comprehensive nature of your cases, be it in civil, be it in criminal, it all embedded in me. And embedded and found in Tice Madox Solicitors, which means that when we take your case out from the foundation in regarding criminal matters, so some of you in this country, you have indefinite leave to remain, limited leave to remain, either through the UK domestic law or you obtained it through the EU law, and you committed offense, either a simple common assault matter, which you think is simple, or maybe you get a caution at the police station, you think it's just a simple matter. Now, let me intimate to you on this in the criminal matter. I don't know why I'm saying this, because I'm talking about deportation here, which is immigration. But I could not help but start and deal with the foundation. The foundation of which you start getting that, or you are now being termed to be a foreign prisoner, having been convicted. That conviction is what I am against. That conviction is what I am here to tell you also, that you need not be convicted because you have not harnessed your case properly. The evidence, remember the threshold in criminal palace and criminal litigation is very high, beyond reasonable doubt. That is why the police do all they can to substantiate the case against you. In the process of doing that, they also leave lacunas along the line in gathering evidence. Now, I have the eagle eye to deal with and scrutinize those evidence against you and present it before the bench, the justices or the district judge in the magistrate court, and also present it before the jury in the crown court to ensure that you are acquitted. Because your acquittal will save you deportation. You see where that comes in, especially if you're in this country and majority of you are in this category, you have indefinite leave to remain or you have leave to remain one way or the other. Your limited leave to remain as a student or whatever category it is, discretionary, humanitarian, refugee, whatever the position is, then these are positions where you find yourself in a situation whereby you could see yourself leave this country for an offense which perhaps you did not set out to commit, an offense which perhaps is a mistaken identity, is an offense which perhaps is a spontaneous offense which you was not set out originally or thought out to commit. But that offense has been committed, or offense which you have been framed. More especially, I get these offenses in relation to sexual offenses, rape matters, sexual touching matters, sexual matters, of which that either or not, the consent or not consent, you've been roped in and you've been accused of either rape or sexual touch or sexual whatever it is. Then in that circumstance, you find yourself to deal with that allegation against you. Whether I call it a blackmail against you, call it a lie against you, but once the police have charged you to take this matter further, you got to now provide an answer. Now, that's where you need me, to ensure that evidence against you, the accuser against you, is being dealt with. Matters in that circumstance are harnessed properly to secure your acquittal. Ladies and gentlemen, you've now been convicted, served the sentence, and about to be deported. Because remember, you're a foreign criminal. And the condition one is that you are a foreigner. A foreigner, I've explained those who are not British citizens. And if you're a British citizen and the offense is serious enough, and it's called serious offense, of which is not in the public interest to leave you, the Secretary of State may, under the power of the Queen, withdraw and revoke your British citizenship, especially if you got a citizenship through naturalization. So it is not the end, which means you ought to be your best behavior. You have to be of good character. Because with little offenses, from common assault to simple little offenses, which carries on along the line, in accumulation of it may become so serious, of which your criminal conviction record is so far. I dealt with a matter where I have a client who had more than 20 pages of criminal convictions, ranging from the youth up to when he's 28 years old. So these are accumulation. They are not serious offenses, but they are little offenses along the line, which obviously spoils the vine. Ladies and gentlemen, the essence is to ensure that you do not get a conviction. Section 32 gives the Secretary of State the power to deport you. Deportation kicks in. Number one, you're not a British citizen. Secondly, it's a serious offense. The Secretary of State will use that power under the law to remove you. Now, subject to exceptions. The exceptions here does not necessarily mean that revocation or the deportation order will be revoked. But the exceptions enables the Secretary of State to at least allow you to remain in the United Kingdom. The exceptions are so many, reeled out in Section 33 of the UK Border Act 2007. Some of you know that, some of you don't know that, but most one that stands out, which probably I will expand on this program briefly, subject to time, is the result of the breach to your convention rights. To your convention rights. Then you can stand as an exception in that circumstance. But that is not the limitation. That is not the conclusion of the matter. That is not the conclusion of the matter. Because it could still carry on. The Secretary of State can still make a case against you, and your deportation would stand and not be revoked. The Secretary of State can revoke it on your own, or is revoked by court, by the tribunal, or by the High Court, whichever way the case is presented. Ladies and gentlemen, I will come in there to discuss that in a brief while. Don't change the dial. I'm discussing immigration deportation today. I remain Justice Maduforo Solicitor, your preferred solicitor. Stick, don't change the dial. I'll be back in 1 second now.
Tice Madox Solicitors is results-oriented, but with a distinctive approach tailored to our clients' needs in our specialist fields: immigration law, criminal law, employment law, commercial law, family law, and contracts law. Tice Madox Solicitors. Try us. We are professional.
Hello, ladies and gentlemen. Welcome back to Law Simplified with Justice. I told you that the Secretary of State can either on his own make the decision to remove you, to cancel that deportation, or the court will exercise its power under its jurisdiction to cancel that deportation order. Now, I told you also that Section 33 enables that deportation order not to take effect, but subject to those exceptions mentioned there. A lot of them are in exceptions there. Ladies and gentlemen, a lot of exceptions in that particular section, which I mentioned to you, are crucial. It's crucial because it is a fundamental, you understand where you're falling. Now, most of the cases that are very common out there comes under the breach of conventional rights. But the case laws, the courts of competent jurisdictions have dealt and interpreted these exceptions, whether your conventional right is breached. Ladies and gentlemen, the exceptions are found under Section 33, which I mentioned to you, and these exceptions are 1 to 5 exceptions. And one of the exceptions where the foreign criminal, as I said, I mentioned the conventional right, also mentioned the obligation under the Refugee Convention. Now, some of you are asylum seekers or recognized in this country as refugees, and you commit this serious offense, and of which that to remove you would be to remove you back to the country where you faced persecution, of which the United Kingdom accepted that under the Geneva Convention 1951, accepted and recognized you as a refugee, but you've committed a serious offense. At that point in time, of which that you have been sentenced to more than 12 months imprisonment. What pretends of you? What pretends of that person at that point in time? Will the Secretary of State remove him back to the country where he is running away from? Of which the Secretary of State have accepted that he faced persecution there and has granted him refugee status in this country under the convention. And then, as a matter of fact, offense committed, 12 months imprisonment, more than 12 months imprisonment, or serious offense, for instance, terrorism offense committed in that circumstance and found guilty and served sentence. Where would the Secretary of State remove that person to? You asked me, your bet is as good as mine, because it is a question left for court interpretation as to whether to remove this person back to that country. Now, this is a case where the Secretary of State will now have to understand and look into that country to see whether that particular situation that made that refugee seeker to leave this country of origin to the United Kingdom, but that issue has long gone. For instance, somebody who is running away from political opposition or political persecution, and it happens that the government of that country at the time was still there, but 5 years down the line, 4 years down the line, 3 years down the line, that government of which he's running away from has now been changed, overthrown, election changed, and new democratic governments or any other form of governance installed in that country. The question now will be that issue of which that refugee is running away from has now been taken care of by a lapse of time. By time, that means that fear has evaporated. It's no longer there. Now, the Secretary of State can exercise his power under Section 32 to remove the person back there. But it requires an investigation and needs to satisfy itself. And some certain circumstances have to get the nod of the court that it is safe to remove that person back to the country where he came from. Talking about refugee status or refugees when deportation matter is in. That's why you need me. When you're facing such a situation, your word, your friend, whoever it is. You see, the beauty of this program is that it's not you that may face this. It might be somebody you need. Remember that you don't need to give somebody money to help the person. If you direct the person to the right place, you have given him more than money. Because the joy that you bring to the person when the family is now settled, case managed well, they have trust in the solicitor who is dealing with their matter. That is enough, more than anything you can give to the person, even your enemies. And they will make peace with you when you send them to Tice Madox Solicitors. Because when they receive better representation and advice, trust me, your enmity will be breached. Because they will be eternally grateful that you've given them this singular number that changed the course of their life. Talking about deceptions now. I mentioned the conventional right, mentioned the refugee status, mentioned also if the foreigner was under the age of 18. At the time of the breach, at the time, let me say this now, at the time, under 18 years of age, on the date of conviction, at the time of conviction. Now, let's say, for instance, that you committed offense at the age of 16 years old. At the time you get convicted, you are still under 18 years of age. Now, this is exception. This exception does not mean that it is a right. It is an exception of which the Secretary of State can consider that, whether to revoke the deportation order or still allow it to go on. I will shock you in a brief moment to let you know that deportation matters are dynamic. It requires that forensic eye, forensic legal examination of the circumstances, of the case laws, of European conventions, and of European Court of Justice decisions, to bring it in, to tally it with the personal circumstances of that individual, family circumstances of that individual, mental circumstances of that individual, and all of the circumstances taken into in totality. You see, that's what you get when you come to me. I've dealt with so many people that have come to my firm this week. Today, I'm talking, is Tuesday. I've literally seen more than 8 people just yesterday alone, and some of these people have come from firms that have dealt with matters for them. And when I took instruction from them, number one, it's very clear. They have not even understanding of what the other representative did for them. Or even if they have understanding, the representative did not put in detailed information that's required to succeed in that application or appeal. Simply because that representative lacked the legal understanding, legal technicalities, the art and craft of legal examination and legal craft to ensure that their client succeed. And informations are completely immersed in that application or appeal. As a result of that, when you don't put this and the matter's now been refused, whatever you are seeing again is you're introducing fresh evidence. And matters of fresh evidence are delicate matters which the court are wary to accept when it's not been disclosed to the primary decision maker. How do you put these informations there? Some of you don't know, some of them that are vital, information that are vital, that are essential, that are required. As a result of that, this applies to immigration, civil litigations, employment matters against your ex-employers, in matters of all natures. Information that ought to be there are not put in because your representative did not have the legal and capacity and understanding and total concept of your case in order to amass your case appropriately. So that is very key. Talking about that, and I moved into talk about the 18 years, under 18. The exception also apply when there is subsection 2 issues applies to Extradition Act. Under the Extradition Act 2003, let me pause there quickly by just capping to let you know that deportation is different from extradition. However, sometimes this intertwine as well. Extradition is either you are accused of an offense or you've been sentenced for an offense and convicted and served a sentence. So two are different. So extradition could be requested from the country where the offense was committed or from your country of origin, requesting you to be extradited down to the country to face prosecution, not persecution. Ladies and gentlemen, I am extensively capable to deal with matters of crime and immigration as they intertwine and to untangle them and to use them in your favor. Ladies and gentlemen, these are exceptions that matters. I don't have much time. Time is ticking. And that's why I said to you on this program that I don't discuss all this. Even this I'm discussing that are just scratching the surface. The reason they are scratching surfaces is because they are not detailed. Your circumstance will be matched in respect to the case laws, which I don't even have time to discuss on here. case laws by High Court of Justice, upper tribunals, case law by Court of Appeal, Supreme Court, European Court of Justice, decisions made in relation to deportation. I don't have time to discuss them here, but I had to fit them into your circumstance. Now, the exceptions go on up to Section 5, hospital orders, if you are, depending on your sickness, depending on if there's addiction going on, quite a lot, because I'm trying to rush up now. And now, also, Section 6 also applied. Now, to shock you also, Section 7, subsection 7 or Section 33, and make it very clear. You see, remember I told you that the fact that your case is exception, and you are relying on convention right, does not preclude the Secretary of State from removing you. It does not preclude the Secretary of State from deporting you. Now, also, let me also, again, fusing that the word removal and the word deportation are not the same. Two different words entirely. Your removal is different from deportation. The terminologies, the application, and the rules guiding them are not the same. In this instance, you are a convicted criminal and a foreign criminal in that matter, and is serious enough for your removal. Now, the Secretary of State, even if you have these exceptions, can still look into that exception and decide that it is still not sufficient enough to revoke deportation order. And he can still go ahead to remove you. He can only do that in certain circumstances. When you appeal outside of the United Kingdom and your appeal succeeds, then he can now be able to revoke that in certain circumstances. So it's a discretion given to the Secretary of State that's so powerful. At what stage, and at what circumstances, or what parameter or threshold does the Secretary of State gauge that discretion is now left for legal discussion and also judicial interpretation. Ladies and gentlemen, that goes into that. Now let me wrap it up. To discuss that singular exception most of you rely on, convention right, European Convention of the Human Rights, and also your Human Rights Act of 1998, at this stage, because of the basis of your children. Children are always a basic point where you hang on convention right. That removing you, though you're a foreign criminal, though you meet the requirements of the removal of the deportation because you are a foreign criminal and you've been sentenced to more than 12 months imprisonment and the offense is serious, you can only be allowed to stay here and you rely on convention right if it is sufficient enough. Now going and assessing your case under Article 8. Article 8 of the Human Right, deciding whether or not this is breached. Assessing it is very crucial because circumstance will enable the court to assess whether or not Section 8, subsection 2 of the Human Rights Act will be injected, which means that even if you have your family right, it can still be interfered. Secretary of State can still use that subsection 2 of the Act to remove you or to deport you. Ladies and gentlemen, I don't have all much time to drag in more to discuss this. And I introduce this topic, deportation. And you know, not just deportation, I do in my firm, and Tice Madox Solicitors, every area of immigration and asylum. Every area of immigration and asylum. Some of you from Syria come into the United Kingdom, you want to seek asylum. Here you have the firm, Tice Madox Solicitors, even if not from Syria or other countries, where you feel persecution, genuine persecution. You may not know that, but when we assess you, when I assess you, I'll be able to know that this falls into asylum or not. Ladies and gentlemen, it is always a pleasure to discuss these matters with you. Deportation is just a very instrumental part of the Secretary of State power to decongest the United Kingdom from foreign criminals or indeed any other matter in their circumstance from having that right, exercising their right to remain here, having been foreign criminals convicted, sentenced within the rules. If your ward, your family, anybody, your friend is going through deportation, you know that it is difficult for them to return to their country of origin, irrespective of how many years they've stayed here, built life here, private life, built their establishment, business, whatever it is they've done here. And the life is hard for them if they return back, but they want to stay. You can fight it. The law has given the exceptions, which means you can drag in, you can pierce in. We will help you do that. Tice Madox Solicitors will help you deal with the matter, ladies and gentlemen. It is all time can permit me to discuss today. I'll ask you to check on our website. Take advantage of all that we discuss, all that we do as well in that firm. And also, you can check us out on YouTube. Type in Justice Maduforo, Tice Madox Solicitors, Law Simplified TV, and also subscribe to our TV station on the YouTube and watch our programs. Ladies and gentlemen, check us on Facebook, Twitter as well. I tell the details are on the screen, and we'll be glad to hear from you. Ladies and gentlemen, time is not on my side, and I have to go now. I ask you to give us a call. I come to the office. Till next time, your time has come, and I remain your favorite solicitor, Justice Maduforo.
Law Simplified with Justice is anchored by Justice Maduforo. Tice Madox Solicitors is results-oriented, but with a distinctive approach tailored to our clients' needs in our specialist fields: immigration law, criminal law, employment law, commercial law, family law, and contracts law. We are well equipped in our litigation and advocacy for the benefit of our clients, corporates, and individuals. Why not visit us at 5 Oakfield House, Oakfield Road, Ilford, London, IG1 1EF. We are just 15 minutes from Liverpool Street Station. Tice Madox Solicitors. Try us. We are professional,